We are all products of our time. Never perhaps such words collectively meant their truest as the times that we live through now. Never before in living memory of its 187 years of existence has the Bengal Chamber witnessed a world so united in crisis, created not by wars but by the global susceptibility to a virus of pandemic proportions. Yet, your chamber, as an institution and as a business collective, has worked and stood through unprecedented times brought forth by the viral pandemic and the devastating super cyclone, rallying all of us not only towards survival, but equipping us in being ready for life and business in the next normal. Just as Tagore said, if you cry because the sun has gone out of your life, your tears will prevent you from seeing the stars. The need is to adopt sustainability, adapt new measures, and practice the new economics of innovation-led progress to turn over a new leaf. Again, as the poet said, you can't cross the sea merely by standing and staring at the water. And so, we got down to work. The Chamber's yardstick of operations is usually measured by the number, relevance, and contextuality of its programs and activities. If a chest full of 110 events puts the stamp on quantity, the qualitative aspects of our program-led and results-oriented activities are certified by the way they have been received by the audience, professionals, and stakeholders from different geographies attending in impressive numbers in person before the pandemic and virtually since then. The year has hit us hard, and your chamber rose to the occasion.
চেম্বার অফ কমার্স থেকে আজকে 500 বেনিফিশিয়ারির জন্য ত্রিপল, ড্রাই ফ্রুটস, বিস্কিট, এছাড়া সোলার ল্যান্টেন, মেডিসিন, এই সমস্ত জিনিস তারা নিয়ে এসছেন, নিজে হাতে নিয়ে এসে এখানে দিয়েছেন। কিছু জিনিস এই স্পটে দেওয়া হয়েছে, রামগঙ্গায় যে মানুষ যারা এফেক্টেড হয়েছে বাঁধ ভাঙায় বন্যার ফলে সেই মানুষের হাতে তুলে দিয়েছেন। কিছু জিনিস আমার ব্লক অফিসে রাখা আছে, যেটা দূরবর্তী অঞ্চলে আমরা পাঠানোর ব্যবস্থা করবো আগামীকালই। তাদের এই শুভ উদ্যোগের জন্য রামগঙ্গার সমস্ত পাথরপ্রতিমা অঞ্চলের সমস্ত আদিবাসীর পক্ষ থেকে, ব্লক প্রশাসনের পক্ষ থেকে সকলকে ধন্যবাদ।
If this was not enough, the sustained work undertaken during lockdown, supporting our government and the citizens was a part and parcel of our operational existence. As the days rolled into weeks, which spilled into months, your chamber embraced the new normal as the new walk of life. The Bengal Chamber, with its managing committee and the expert committees, under guidance of the past presidents and with overwhelming support from the membership and all stakeholders from near and far, embarked on a journey in which geographical barriers and distances were nullified. Digital and virtual became the realities of the day. This seamless transformation of bringing together people from all corners of the globe, addressing core issues of business, health, social and economic aspects is captured in a montage. What we have experienced is that our pre-pandemic and post-pandemic programs may have been held on different platforms, but the intensity of engagement from participants has only strengthened over these 100+ activities. The learnings were aplenty.
We will have to work in terms of taxation, in terms of policies for transfers to the poor. And though I'm saying that right now we cannot be obsessed with those big long-term changes. We have to worry about that very, very quickly, because the level of inequality we have in India is unacceptable, and we have to work on that.
I know the NEP talks about it, and I'm totally in favor of having more of our foundational education in Indian languages. And there needs to be a way of making sure that this is done even in elite schools. Otherwise, we'll end up with a two-track country. However, while the theory of this is good, the practice of it, however, needs to be thought about from a very basic perspective, which is that the textbooks and curriculums in Indian languages need to be radically upgraded and updated.
The SWOT analysis, which has been done by the chamber, it mentioned that credit is a major issue. Now, with this growth in the credit, which has been witnessed in the state, this is a problem.
The critical verticals of the economy and business were blended with talk shops and programs on a plethora of subjects. Even the Chamber's signature activities were held for a global audience, with participation climbing into several thousands.
We are moving from a consumer era to a post-consumer era. I mean, we had excesses in our lives, in our behavior, in our spending. But now we are all going to look towards for health and a better balance in what we are going to do.
We are doing certain things in order to be part of the region, but not adequate. It's not making the impact, because a lot of this is G2G, government to government, not enough P2P, people to people, and certainly not enough B2B, business to business. And relationships today in the modern world are less and less about G2G. They are more and more about B2B and P2P.
So we want to have a national depository of knowledge, national practice for each and every item which is being imported in this country.
We are hoping to advance 5 key campaigns to support the reduction of emissions. We want to support a campaign on the transition to clean energy, and India is leading the world in many ways with its 450 gigawatts commitment on solar energy. The switch to clean transport, and I think there are huge opportunities for India to lead this work in this sector, particularly for 2- and 3-wheeled vehicles. A campaign on nature-based solutions to demonstrate how mangroves like Sundarban can not only, protecting mangroves like the Sundarban can not only help protect communities and help them be more resilient to the effects of climate change, but can also help serve as a carbon sink to mitigate climate change itself. Work on adaptation and resilience, which is particularly important in neighbouring Bangladesh, for example, and other low-lying areas prone to flooding. And then underpinning all of that, work on finance.
2 principal focus areas, especially during this time, are people and health. On both, the Chamber has communicated learnings, best practices, and even advisories over and over again to the community at large, going much beyond the immediate business fraternity.
The concept of herd immunity is when you have random spread of a factor and there is 60 to 70% of individuals who are unable to be affected by that factor, that constitutes herd immunity. And if we're all people and the virus infects people, then whether it's a herd in the US or a herd in India, the herd is the herd, right? It's worldwide, but the development and the speed with which immunity develops, that is locally dependent, right? So wherein we in the United States have taken social distancing in some areas to heart, and people have been in their homes for weeks, herd immunity is actually developing very slowly, but in those areas, infection rates are going down. We recognize that eventually we will develop 70% of people who are immune, and that will allow us to save lives, not just because you infect less people per se, but it's because the resources to treat those people become available when they get infected.
Life goes on. Setbacks are always temporary. We fall because we can pick ourselves up again. The Chamber believes that lives and livelihoods are and will be the defining features of this normal that we are living through. In this journey, we have focused as much on addressing the business ecosystem as we have on celebrating life.
আপিসপাড়ার খাবার এই যে ইনিশিয়েটিভটা, এটা আপনারা সকলে দেখতেই পাচ্ছেন প্রায় উৎসবে পরিণত হয়েছে, এবং এটাই আমাদের ইচ্ছে ছিল যে এত ধরনের মানুষ, এত ধরনের খাবার, এত ধরনের রান্নাবান্না প্রত্যেক দিন এরা করে, এবং এদের কোনো স্বীকৃতি নেই সেই অর্থে। হ্যাঁ, আমরা জানি যে আপিসপাড়ায় খুব ভালো খাবার পাওয়া যায়, কিন্তু আজকে সাধারণ মানুষ সবাই বাইরে থেকে এসে সবাই মিলে খাচ্ছে। বেঙ্গল চেম্বার অফ কমার্স থেকে এই ইনিশিয়েটিভটা আমরা নিতে পেরেছি, তার জন্য খুব ভালো লাগছে, এবং সাধারণ মানুষ এইভাবে সাড়া দিয়েছেন, তার জন্য অনেক ধন্যবাদ।
কলকাতা হলো শিল্পের শহর এবং শিল্পীদের শহর, আর সেই জন্যই হেলো হেরিটেজ। হেলো হেরিটেজ একটা আর্ট অর্গানাইজেশন যেখানে আমরা আর্ট অ্যান্ড আর্টিফ্যাক্টস কে প্রমোট করি, যেখানে আর্টকে দেখা হয় আর্ট থেরাপি হিসেবে। 2002-তে যাত্রা শুরু, বিভিন্ন শাখা প্রশাখা বিস্তার করেছে হেলো হেরিটেজ, কিন্তু আমাদের একটাই ট্যাগলাইন, এক্সপিরিয়েন্স ইয়োর হিস্ট্রি। আমি রেশমি চ্যাটার্জি, ফাউন্ডার কিউরেটর হেলো হেরিটেজ। চতুর্দিকে ছড়িয়ে ছিটিয়ে রয়েছে আমাদের ঐতিহ্য, এখানে রয়েছেন শিল্পীরা। তবে হ্যাঁ, সেই শিল্পীদের কিন্তু একটা প্ল্যাটফর্ম দরকার হয় এন্ড অফ দ্য ডে। তার কারণ শিল্পীরা যেসব দ্রব্যাদি বা সামগ্রী তৈরি করে সেগুলোকে যদি তারা মার্কেট বা বাজারে না নিয়ে আসতে পারে, অর্থাৎ সেখানে যদি বিক্রয় যদি না হয়, তাহলে কিন্তু সেই শিল্পীরা বাঁচবে না। আর আমরা বিশ্বাস করি একটা মুদ্রার দুটো দিক, একদিকে শিল্প, একদিকে শিল্পী, তাদেরকে বাঁচিয়ে রাখতে হবে। আর সেটার কথা ভেবেই হেলো হেরিটেজ একটা প্রমোশনাল প্ল্যাটফর্ম প্রোভাইড করে এই শিল্পী বন্ধুদের। আমাদের যে বোধোদয় ইউনিট কাজ করে, সেখানে আমরা বিশেষ করে কাজ করি মেন্টালি চ্যালেঞ্জড এবং আন্ডার প্রিভিলেজ চিলড্রেনদের সঙ্গে। তারা যে ভীষণভাবে একটা ক্রিয়েটিভ মাইন্ডের অধিকারী আমরা বিভিন্ন ওয়ার্কশপের মাধ্যমে দেখেছি।
সবচেয়ে বড় কথা হচ্ছে হেলো হেরিটেজের এই কাজে বিভিন্ন গভর্নমেন্ট ডিপার্টমেন্ট আমাদের সাথে যুক্ত হয়েছে, যেমন খাদি বোর্ড এবং ওয়েস্ট বেঙ্গল মাইনরিটিস অ্যান্ড ফিনান্স কর্পোরেশন আমাদের সাথে যুক্ত রয়েছে এবং সর্বোপরি হিটকো রয়েছে।
আমি কাজটা যখন শুরু করেছিলাম তখন একটা প্যাশন থেকে শুরু করেছিলাম, তারপরে কিন্তু যখন কাজটা নিয়ে আমি এগোচ্ছিলাম তখন দেখলাম পথ মোটেও মসৃণ নয়। সেজন্য যেটা ভীষণভাবে দরকার হয় সেটা হচ্ছে ধৈর্য। যে কোনো প্রজেক্টের কন্টেন্ট যদি ভীষণভাবে জোরালো হয় এবং সত্যি সে যদি এই সোসাইটির জন্য কাজ করে, তাহলে কিন্তু তার পথ চলতে কোনোদিন কোনো অসুবিধা হবে না। কলকাতা হলো শিল্পের শহর এবং শিল্পীদের শহর, আর সেই জন্যই হেলো হেরিটেজ। হেলো হেরিটেজ একটা আর্ট অর্গানাইজেশন যেখানে আমরা আর্ট অ্যান্ড আর্টিফ্যাক্টস কে প্রমোট করি, যেখানে আর্টকে দেখা হয় আর্ট থেরাপি হিসেবে। 2002-তে যাত্রা শুরু, বিভিন্ন শাখা প্রশাখা বিস্তার করেছে হেলো হেরিটেজ, কিন্তু আমাদের একটাই ট্যাগলাইন, এক্সপিরিয়েন্স ইয়োর হিস্ট্রি। আমি রেশমি চ্যাটার্জি, ফাউন্ডার কিউরেটর হেলো হেরিটেজ। চতুর্দিকে ছড়িয়ে ছিটিয়ে রয়েছে আমাদের ঐতিহ্য, এখানে রয়েছেন শিল্পীরা। তবে হ্যাঁ, সেই শিল্পীদের কিন্তু একটা প্ল্যাটফর্ম দরকার হয় এন্ড অফ দ্য ডে। তার কারণ শিল্পীরা যেসব দ্রব্যাদি বা সামগ্রী তৈরি করে সেগুলোকে যদি তারা মার্কেট বা বাজারে না নিয়ে আসতে পারে, অর্থাৎ সেখানে যদি বিক্রয় যদি না হয়, তাহলে কিন্তু সেই শিল্পীরা বাঁচবে না। আর আমরা বিশ্বাস করি একটা মুদ্রার দুটো দিক, একদিকে শিল্প, একদিকে শিল্পী, তাদেরকে বাঁচিয়ে রাখতে হবে। আর সেটার কথা ভেবেই হেলো হেরিটেজ একটা প্রমোশনাল প্ল্যাটফর্ম প্রোভাইড করে এই শিল্পী বন্ধুদের। আমাদের যে বোধোদয় ইউনিট কাজ করে, সেখানে আমরা বিশেষ করে কাজ করি মেন্টালি চ্যালেঞ্জড এবং আন্ডার প্রিভিলেজ চিলড্রেনদের সঙ্গে। তারা যে ভীষণভাবে একটা ক্রিয়েটিভ মাইন্ডের অধিকারী আমরা বিভিন্ন ওয়ার্কশপের মাধ্যমে দেখেছি।
সবচেয়ে বড় কথা হচ্ছে হেলো হেরিটেজের এই কাজে বিভিন্ন গভর্নমেন্ট ডিপার্টমেন্ট আমাদের সাথে যুক্ত হয়েছে, যেমন খাদি বোর্ড এবং ওয়েস্ট বেঙ্গল মাইনরিটিস অ্যান্ড ফিনান্স কর্পোরেশন আমাদের সাথে যুক্ত রয়েছে এবং সর্বোপরি হিটকো রয়েছে।
আমি কাজটা যখন শুরু করেছিলাম তখন একটা প্যাশন থেকে শুরু করেছিলাম, তারপরে কিন্তু যখন কাজটা নিয়ে আমি এগোচ্ছিলাম তখন দেখলাম পথ
মোটেও মসৃণ নয়। সেজন্য যেটা ভীষণভাবে দরকার হয় সেটা হচ্ছে ধৈর্য। যে কোনো প্রজেক্টের কন্টেন্ট যদি ভীষণভাবে জোরালো হয় এবং সত্যি সে যদি সোসাইটির জন্য কাজ করে, তাহলে কিন্তু তার পথ চলতে কোনোদিন কোনো অসুবিধা হবে না।
সবাই এসে গেছে, জয়েন করেছি সবাই? জয়েন করলে
I have joined. Ritika is also here. I can see Ritika now.
Kullan sir, can you hear us now? We are going to start our webinar. Before that, I'm going to give you a short technical brief that we have kept all our speakers and panelists in Zoom mode, and rest of our audience will be able to hear us, see us, but we have kept their audio and video mode on mute so that there's an ease of running this webinar. I hope Kullan sir can now hear us properly too. Without further ado, we would like to thank all our speakers and our partners of this program for helping us to convene this session. I would request the chairperson of our legal committee, Shri Deep Narayan Mitra, to formally begin our today's webinar. Over to you, sir.
Good evening, ladies and gentlemen. As chairman of the legal committee, Bengal Chamber of Commerce and Industry, this evening I have been given a very daunting task to give a preface to the panel discussion on Indian data protection law, whether it is a boon or bane for the businesses. I say it is daunting for me because I am in the company of such knowledgeable and experienced people in the field of data protection today, where my knowledge about data and data protection is very limited. Over a passage of time, I have been able to learn how to operate a computer, how to verify my mails, reply to them, or at the highest making some web surfing. Therefore, I am very limited in so far as the experience is concerned. As I learned, data in today's world is such an important tool in the hands of the society. As Dr. Belani says, data is the new oil in the 21st century. It has been compared with oil, which has changed the world and at the same time is very expensive in today's market. Supreme Court in its landmark judgment in Justice case Putuswamy versus Union of India has held that informational privacy is akin to right to privacy under the Constitution. For the growth of business in today's world, there must be a balance between imperatives of protecting privacy through ISO 27001 compliance and ensure innovation and economic aggrandizement in states in tech policy, data regulation, and data privacy. There should be three flavors in talking about data. That is, one is personal data, which is absolutely personal to an individual. There may be sensitive personal data, which is financial data, health data, biometric data, etc. A non-personal data, which is census data, metadata collected by various service providers like Uber, Ola, etc., etc. I'm sure the speakers today would enlighten us more, and we are eagerly waiting for the moderator of the program today to start the program. Today's moderator is one of our legal committee members, Mrs. Sucharita Basu, who is a lawyer and hails from a well-known family lawyer family in Calcutta, and is a partner of a law firm. With this, I hand over to Sucharita. Kindly proceed.
Am I audible by everybody? Shukarna, can you just confirm if I'm audible?
Yeah, you are.
Okay, very
you
good.
are.
Thank you, sir. So, namaskar
You are audible.
Yes, great. So, namaskar and good evening, and a very warm welcome to today's session, which is, of course, the first session, as D.N. Mitra sir said, from the legal committee of BCCI this year, and it also happens to be my first session with BCCI as its managing committee and legal committee member. And it will be really an understatement to mention how glad I am for it, if not anything else, with the prestige attached to this chamber. Now, while we were discussing topics for this session, we had several ideas, but we selected data privacy in business because we thought it is modern, and also it is, or soon it will be absolutely imperative for the entire business ecosystem to comply with the same. Now, by now we all know that we are under constant data sharing mode with our hardwares like our phones, smart TVs, laptops, softwares, like every application that we use. And we are sharing data with the government, our employers, our service providers, and for that matter, I think even at the security of many office buildings, hotels, shops in the mall that we walk into. Now, the recipient of this data, it broadly needs the data for two purposes. A is for providing service to us, such as an Uber or a Zomato or an Airbnb, or for collecting employee or personal data for creating their own database for security or for better administration or diverse operational purposes, such as a TCS or a Cognizant. Now, question, however, is that how can such enormous amount of big data, which is procured through data mining or collection or collation, they are helpful for businesses and consequently to the macro socioeconomy? Or is it that its long-sighted advantages, they are far outweighed by the present painstaking tasks of ensuring the logistics, the security concerns, the legal compliances, and dealing with the punishments for contraventions or non-compliance thereof? Now, so in this backdrop where monetization of data by corporates, it is pitted against the privacy referendums of consumers, India is at the threshold of implementing a comprehensive legislation on data protection. It is aspired that this impending legislation will encompass a lot of new concepts such as principles of consent, data segregation, risk analysis, sound security measures. But it is also apprehended that it will significantly increase compliance cost and burdens for the businesses, and it will also overstate government intervention. So it is really a cost versus benefit analysis situation for businesses, and that is exactly what we shall try to discuss today. This session has been curated with panelists who will give us a much needed insight into the legal landscape of data protection, which will equip us to understand on how to strike a balance between flexible and scalable personal data, and in order to support a data-driven business model, and the security and the privacy aspects which is required to maintain a viable business. So the deliberations will be in a panel discussion format wherein I will sort of hop, skip, jump to and from each panelist depending on the theme of the queries and the responses offered. We do have a short presentation where the panelists' introduction presentation, which Shukana, if you can show it on the screen, if you can share it on the screen, then I can maybe quickly run through it. Yes, so as you can see, we have with us Shri Kalyan Mukhopadhyay. He is IPS DIG Special, and he is he's really very much. In fact, he was discussing with me this morning about the new data laws, the current data laws, and I'm sure he will enlighten us with his experiences. Then we have with us Mr. Vivash Chatterjee. He's a special public prosecutor for cyber law and electronics evidence for the entire West Bengal. And he's author of several books with respect to this subject. And he has also developed several mobile apps. So we will definitely benefit from his knowledge about the new law. Then we have with us Professor Rajesh Babu Ravindran of Law and Policy at IIM Calcutta. And he's a lawyer by training and over 2 decades of experience in industry and academia. And he will also, I will ask him questions on the policy and the background of the law, and which I'm sure he will be able to enlighten us with. We have Yukti Sharma, Assistant Vice President Legal, Piramal Capital and Housing Finance, and she's also the Data Protection Officer of Piramal Corporate, and she has been advising the group on data protection compliance and related aspects. And Yukti is, of course, known to me very well, and I think she's one of the most knowledgeable people in the country doing data protection compliances today. We have Joy Jyoti Mishra, Director and Head Legal South Asia and India, Uber. his role is very important because Uber, as you know, is an organization which is based on data. It is part of a shared economy, and Mr. Mishra's role requires him to advise the company on diverse matters, including on M&A, privacy, corporate and commercial matters, competition and antitrust issues. He was my ex-colleague as well as in Khaitan when we were both there. And of course, Joy will be a great addition to this, especially from the business perspective point of view. Ritika Banerjee, she's cybersecurity consultant at Accenture, because like I said, the data is of two kinds. One is for the employees for administrative purposes and the other is for business purposes. So Ritika's role as a cybersecurity consultant, when she's presently associated with Accenture in the data privacy and protection department, it definitely becomes an integral part of this discussion. So we've got a diverse panel and we'll try to get their feedback on this subject and tie it up with a common thread. So I would like to start the discussions, if that's okay. Should I start?
Yeah, please go ahead.
Yes. So my first, yes, thank you. So my first question is obviously to Professor Ravindran, that these all legislations are actually, they are made to address causes and sub-causes leading to policy problem statements. So what are the policy action points that personal data protection law is targeted to address in India? And do you think that the content and the construct of the Personal Data Protection Bill 2019, it is technically correct, it is politically supportable, and organizationally implementable, considering that India is a country with diverse and extremely heavy population, most of whom are either uneducated or less educated to understand or appreciate the law and the protection that it can offer to the data principles. Now, before you answer that, I would like to tell that in today's deliberations, few technical words may have to be used, common ones being data principles, meaning the provider of the data, I'm sorry about that, provider of the data, and data fiduciary, meaning the person receiving the data. The use of the word fiduciary in this context itself implies, involving trust, like a relationship of trust, as it is, as in wherein he's being trusted, it is being trusted with my data. So coming back to Professor Ravindran, if you could answer my questions. Thank you.
Yeah, good evening to all, and thank you very much for your kind invitation to the Bengal Chamber of Commerce. It's a pleasure for me to be here and to interact with the wise audience. Just to briefly, before even moving on to the data protection bill itself, one should understand that India as a country in the last couple of decades have leveraged on its position as an outsourcing destination in the context of information technology enabled services that saw a boost in the 1990s, right? Which kind of made it a hub, in a way, a back-end non-core service outside the Western countries and to low-cost locations like India. So one of the reasons why we developed was because of the transferability of these data, the storage of easy storability of electronic data in central computer system, access to both internal users as well as vendors, etc., right? So the Indian ITs and the BPO and KPO industry came to handy and access all types of sensitive and personal data of people around the world on daily basis. But what we did lack was a comprehensive kind of regulatory structure, internal regulatory structure. So when we look at the US and the EU, of course, to a large extent, the EU GDPR, they have put up a structure which is very, very progressive, very, very protective in terms of personal citizens' data. And as a country, majority of our technology-enabled services are dependent on sourcing or processing some of these EU citizens' data. So irrespective of whether we have law or not, the bill is there or not, many of these countries are expected to follow. If they are supposed to kind of use EU citizens' data, they are expected to follow EU GDPR, right? So in other words, irrespective of a structure in our country, indirectly, Indian companies who are dealing with European data, for instance, are compelled to follow many of the provisions that are there in the EU GDPR. So our bill comes from there. I mean, it's kind of strongly kind of, influenced by the EU GDPR, which is kind of very pro citizen or citizens data protection, more than the corporate sensibilities, which the US, for instance, are kind of balancing it out. So EU has largely gone towards, one should say, bit of, because one could say that, a bit of bias in favor of the personal data protection, right? So exactly the same kind of situation you find. And in the context of the Supreme Court judgment in Puttaswamy's case, this becomes even more important to understand our data protection law, which again has implication far beyond India as country seeks to develop a comprehensive data protection. So it is imperative as a country who wants to deal with data, who has an industry based on data services, has to have a very strong fundamental legal structure if they want to progress, and if business wants to come to India in a large way, which we are trying to project, right? So it is imperative that we need a structure. And if you look at the framing of the act itself, that kind of captures most of these issues. And as I said, with a bit of tilt more towards the personal data protection. So the bill is the result of an engagement and consultancy process that has been widely circulated. These interests include Indian law enforcement desire to access US stored data during investigations, and the aversion to so-called, what is called as data colonization by large Western technology firms, a grievance against large-scale collection of Indian citizens' data by Western companies, etc. Right? So protection. So
yeah.
So just one more point, and I'll stop. The core of the bill is on giving right to the individuals to control over their personal data, and at the same time giving obligations to those entities who record and use personal data to be open about their use. These are the two key issues which I would say centers around the entire bill is kind of structured. Of course, it has its problems, plus and minuses. We can get into that later on.
Correct.
Thank you.
So maybe probably we can get into that with Mr. Chatterjee. So as you said, this is largely for protection of the rights of the data principle, that is the people who are sharing the data. So Mr. Chatterjee, can you enlighten us on the perspective, from the perspective of the Puttaswamy judgment, where right to privacy was recognized as a fundamental right, and then what happened and how did the bill come into force? I mean, the bill came into existence. Are you on mute?
No, it's okay.
Very well.
Is it okay? Yes. So it is rightly said so by my previous speaker that we have taken a lot of concepts from the GDPR, though there are differences between GDPR and our personal data protection bill and all. But coming to the basic origin, we have to understand, our industry has to understand, our people has to understand that the Europe has more than 30 years privacy legislation experience, which India does not have. We are since long trying to inbuild or inject the word privacy within the concept of fundamental right. We got success first time in the year 2017, and in the year 2017, I can quote the citation, 2017 volume 10 Supreme Court cases, page number 1. The Justice case Puttaswamy and another versus Union of India. And in the para 77 of that judgment, it was emphatically stated that right of privacy is a fundamental right. And the most important thing coming out of the analysis of this judgment is that this is not the general privacy alone. It's a data privacy. Because ultimately it is the data. And because India is on the threshold of to be called world's second largest internet user, so data means the online data or virtual data or data which is presented in electronic platform or the virtual world and other. Now the question here, I again am repeating the point, the situation is unlike the European Union or other developed country where UK has their data protection law in prior 20s. So what we have to learn from, this is the origin, and thereafter we know the Sri Krishna committee was made, and then Sri Krishna committee has given a draft bill. On the basis of that, we got the data protection bill 2018. Then there was an amendment and changes some of the sphere, and bill 2019 came into effect. Now going through the entire bill, you see the most important thing is what is personal data, or should I say the most sensitive personal data. If you go through the definition of the sensitive personal data, you see that financial data, health data, official identifier, sex life, sexual orientation, biometric data, genetic data, transgender status, intersex status, caste or tribe, religious or political belief or affiliations, or any other data categorized as sensitive personal under section 15. Now, unlike the GDPR, the GDPR, subject to corrections, never speaks about the financial data, which is there in Indian law. So I think this is going to have a very important effect in our industry as well, because industry works on very much on financial data, and definitely there are other data as well. And the section 4 has categorically stated of that bill that no personal data shall be processed by any person except for any specific, clear and lawful purpose. What I mean to say that I'm more pessimistic on the application of the law. Well, we have drafted a bill. We have taken or imported some concept from the countries who already have long history of data privacy law and that their culture of that. See, for example, in the GDPR, there are a 2-year phase given for preparations. And if the same way we follow the same model in Indian law, I think that will be catastrophic for our Indian industry. What I see in Sector 5 and other areas, because I'm working as a special PP since 2000, you all know that since 2013 and 14, and lot of cases we have seen against the call centers and the call center scam. People are sitting here and earning unlawfully using the data and other from the other part of the countries. And slowly India is becoming blacklisted in the international world on that sphere. And I have gone to the international seminar. I have also seen the same situations and protests are going through there. Now the point is, in such a scenario where data is of not that important thing, we are all telling that data is oil, data is air, data is everything, and there are data brokers who are all the time playing with the sensitive data of the people at the end of the day, the individual people. And it is definitely the welfare policy of a state has to be centered around a person's personal liberty or right, and which includes the privacy. But the point here is implementing this law, because if you take it from the technical perspective, what I have seen that if we going to implement the GDPR, what I'm always telling about, I'm not telling about take everything in pessimism. We have some optimism as well, because GDPR and long prior to the GDPR, we have data bill, that's the IT bill 2011. We have Information Technology Act section 43, especially 43A. And with the inception of this bill, I think the 43A will no longer be there. There are section 72 and 72A all there related to privacy and breach of contract, and all the issues are there. Now, whether in spite of having these laws for the long years, whether we have learned to give honor to the right of privacy to individual, or whether we are playing with the data in two perspectives. What you have stated is absolutely, there are two perspectives. One, the data of the employee who are working in the field or within the organizations. And again, Another thing is that the data with which on the larger perspective, the companies and the corporates are working. Everybody is working on data. And everyone, I'm not telling about the non-governmental sector, even the governmental sector, the bank and everyone, the way they're playing with the personal important data, starting from Aadhaar to everywhere. It's very alarming what I'm seeing from the grassroots level. But every day, the investigating agency is coming, cracking different cases, and they're coming with the case diaries. And when going through those documents, I see there are hundreds of forged Aadhaar card. I've seen that in a single Aadhaar name, there are 100 people's face or photographs in pasted, and there are a lot of QR code being pasted on that. These are actually alarming. And in this scenario, if we're going to impose a law which is earning for a non-bailable, cognizable offense in case of non-compliance, and that too, if in case of financial sector, penalty sector, it going to 15 crore and all these to 4%, and then next car 5 crore and then 2%. I think, and in case of non-audit and all this, I think we need a more time for preparing ourselves. Definitely law is very much required. We are standing in the threshold. If the Brazil can come with a data privacy law, forget about the California CCPA law. I'm telling about if the Brazil, India, China, all are in the same developing footing. And if the Brazil can come, because what I'm telling, if you go by the data protection bill and the GDPR, the most important thing is if we can make ourselves compliant, and there will be hard pensive, lot of cost have to be taken, have to be borne on. All these issues are there. But after 2-3 years, if we become at least little bit of compliant with this GDPR and obviously our bill, which is going to be act in the later part of the year or maybe next year. So it will going to give a very positive note of Indian corporate to the international world, because if you go by the GDPR and other law, if there is any private cyber security breach in your industry, you have to explain or inform the person whose data you are processing within 3 days of the breach when you get the knowledge. So these are very good culture. We will think for making our cybersecurity policy more strong and the more resilient and more strong our presentations or appearance in the international field in light of the fact that the world biggest outsourced IT industry now India is having. So in that heavy labor industry, heavy employment industry, and we have a large scale of skilled manpower. In this perspective, that is why I have straightway given a request to the government of West Bengal to have at least 1 hour, 2 hour session on GDPR to all the stakeholders of the industry, and the government have been approved that plan, and I have a 2 hour session on GDPR, because what I think at the end of the day, if this stakeholder doesn't understand the importance of the data culture or their law, especially the huge phenomenal law of the GDPR, then I think there is little bit, hardly the companies are there after getting that kind of fine or penalties, they can again stand up and in the industry.
Correct.
So that I think is a right thing.
Yeah, thank you so much. That was very insightful. So that will bring me to Yukti, who has already, complied with EU GDPR in her past organization as well as perhaps in her current. And Yukti, can you very briefly touch upon the basic tenets of the Personal Data Protection Bill with respect to its practical application from the business perspective, and also a little lucidly as to why EU GDPR, because many of our audience may not be knowing that EU GDPR should be applicable to them. So why exactly should we bother? We are sitting in India, why should we be bothered about EU GDPR at all?
Thank you. Hi, everyone. Going to your first question, the chief tenets of the proposed bill. Like we've already touched upon the actors, which is the data principal and the data fiduciary. I think the most important aspect is what does it cover? And that is the definition of personal data. And this definition is a very wide definition. It says any data which identifies a natural person, which can identify a natural person, or can be identifiable to a natural person. And this is in line with the personal data definition under GDPR. And honestly, there is a perception that when people do not take simple things like name, phone number as personal data, they will, while I deal with queries, they only become a bit sensitive when they say, okay, it's a PAN number or maybe it's Aadhaar number. That's when they're like, okay, that's personal data. But honestly, if you look at the definition of personal data, it is anything which connects to a natural person. And that's how we look at it. That's how the applicability begins. And that's the whole gamut which we need to look at. And then the second aspect which becomes important is sensitive personal data, which was again covered by Professor Ravindran. When you look at, just to give you some example, the classification for sensitive personal data is done on the basis of the harm principle. And harm principle, if I were to explain, is the measure or the amount of harm which can happen to an individual if the data is processed incorrectly or breached or misused. So when any jurisdiction is looking at sensitive personal data, the harm-based principle is something which is looked at, which is also something which even GDPR considers. So when our draft bill has been proposed, some of the points which are there are financial data, health data, sexual orientation, biometric data, data with respect to official identifiers. Basically, these items are perceived by the committee as data being items where there could be harm to the individual if the data is misused. So having dealt with the two aspects, because these are the two aspects which will be relevant in how you deal with the data in your day-to-day activities, whether it's personal data or whether it's sensitive personal data, and you need to be extra careful for sensitive personal data. Another aspect which is important is that an authority has been proposed, which is the Data Protection Authority. And if I were to draw a parallel, it would be something similar to a supervisory authority in the EU for GDPR. And why this Data Protection Authority becomes very important is that this authority, apart from, actually being the authority which will adjudicate all the disputes under the proposed bill, it will also be responsible for making the rules and, doing the registrations and providing clarity on the provisions on how should you go ahead and process, or how should organizations be guided. So like Mr. Ravindran had pointed out that, EU has been, even Mr. Chatterjee, that they've had so much experience with data protection legislation for so long. For us, it's going to be one of the first time that we're going to have a comprehensive data protection legislation. And therefore the role of the authority becomes quite crucial, because the authority and its competency will determine how well, firstly, it is implemented, and secondly, how they provide clarity to questions, because it is such an evolving field, and it has probably been accelerated because of the pandemic, that data is being generated and work is being done digitally. A lot of work, a lot of data transfer is happening digitally, which didn't happen previously. So, and there are unique problems which can arise with the changes in technology. So to have a regulator who you can go to and, seek guidance on how should an organization process or go ahead with their processes, I look at it as a positive step, and we are very hopeful that this authority is able to live up to its role. Another aspect which is a very visible aspect of data protection law, because when the law comes into effect, there's a lot of work which happens in the background. But what is visible to us usually, if you pay attention, is the consents which are taken, because most of your consents these days on websites, they are those you're supposed to click on move ahead. And the idea of consent in the proposed bill is to make it very simple, to make it understandable. So somebody who's agreeing should know what they're signing up for. So they have looked at a very customer or data principle friendly definition of consent, so that the person who's signing up and sharing the data knows what they're agreeing to. This is again in line with GDPR. In fact, at some places we could be probably even more stringent over there. And so consent becomes important. And with consent, there is another aspect which is visible, which is your privacy notice. So if you look at any website and you go, it's somewhere on the bottom right, or there is always a link for its privacy notice or privacy policy. And that is again a way of ensuring transparency, so that the person whose data is being processed knows what data is being collected. So typically a privacy notice will tell you, this is the data I'm collecting, this is what I'm going to use it for. If you have a grievance, then you should contact perhaps the data protection officer or a grievance officer or any other person who's been designated. So that is the first interface which a user has with an organization, where they know how their data is being being processed or being used by them. So that is from the visible aspects of data protection. And I will just touch upon the principles. So just the basic principle which has been proposed in the law is that when you process data, you should do it fairly. That means you should do it for the purpose for which it has been collected, and to sort of empower the individual so that they have control over the data which they've shared with an organization, and the onus is on the organization or the data fiduciary to make sure that they process it transparently, fairly, collect only that much that is required. That's called data minimization. Then there should be, there are a lot of other principles also.
Yes. So
but
it's quite
this
a
is
robust law, that is for sure, and it is very much essential. So now, for instance, Joy, who's in Uber itself is a data giant, considering the enormous amount of data related to users, location, transaction, communications that is collected by your organization. So on the privacy policy point, Joy, can you tell us such kind of a privacy policy? And generally when we come to consent also, we see this 26,000 words agreement where I cannot read anything on the phone and I just have to click on I agree. So is that going to remain the way it is, or will it be customized for the demography, for the kind of users that are supposed to be using that particular product? Or will it be an audio consent also, or audio reading out of the agreement? How do you think we can cover it for a country like India? Has Joy dropped out by any chance? Yeah, I think he has dropped out. I can't see him.
In the meantime, Sucharita-di, if you can
yes, so
talk to Kolanda, because I think he has to leave.
He has to
got
leave?
another meeting.
Okay.
Yes, he has to
No,
leave
I
by
thought I will take Ritika before him, but then no issue, because Ritika is being the Chief Security Officer. Maybe one by one they can answer this question. And this is a very practical question which I have for Mr. Mukhopadhyay, is that about the current trend and the kind of cyber offenses under the extant laws and the standard course of investigation which is adopted by the police authorities once such an offense is reported. If you could help us with the answers. You're on mute, Mr. Mukhopadhyay.
Is it okay now?
Yes.
Good evening to all of you. I was actually completely engrossed into the very rich deliberations given by the previous speakers. I will go to rather some very grassroots level.
Right.
We have studied the crime patterns in the last 1 year, most of the corona period. And we found a very interesting fact is that the theft, the robberies, dacoities, snatching, all these crimes against property have decreased a lot in different units of West Bengal. On the other hand, the digital crimes, they have increased. The reason is very simple, that people were at home. So thieves, they didn't have a good time for them. What is happening is, what is worrying us is, we have to think which is the target, which should be the target group of training. I feel, rather we also feel from police, that it is the group from probably 16 to 25 years of people who are using mobiles and who are using most recklessly. One is for their adventurous nature at that age, that they are not taking enough precautions. And the other part is definitely, we haven't started yet to train them right from the school age. I think from the class 6, 7, 8, they should be trained that what are the dangers associated with using mobile phones, internet, etc. Because nowadays it is more pertinent, as most of the classes are now online classes. And most of the children and young youth, the young boys and girls, they are using WhatsApp, Facebook, etc. Most of them. So that is there, that this target age group must be there. And then there is one more point. As investigating agency, we are finding that we are getting lots of delayed actions from different companies in the social media sector. Say from Facebook or Twitter, etc. Whenever we are trying to get something, we have to pursue a lot. There should be a very stringent law. Time-bound information must be given. Say for an example, if there is a sort of morph picture of a lady in a social media, and if we take 3 days to stop it or to take action against them, so for 3 days, thousands of people are seeing that picture. So the lady is getting affected for the system. So there must be a very stringent law in the country that within this much of time, the data must be provided to the investigating agency immediately. Problem is, the concept of individual freedom in social media is different in America than to India. So we have to go to some sort of consensual idea that this much of time is needed, or these are the agencies we should get immediately and we can take action immediately. The other part which we failed as investigating agency is that there is a tendency now that all the data which we now call are kept in one room storage system.
Right.
So it's a very basic thing that if you keep your jewelries in 3 boxes, then the thief can come and break the lock of one box and take one, other 2 at least remain intact. If you keep them in one box, okay, fine, it is very easy to get the jewelries. Whenever you want to get one of them, you have only one key for one box, fine. The problem is the key should be very good. And that is, unfortunately, is not now in our system. We have cases where a very senior officer of a district has given his password to 3 low-rank operators. And one of those operators, he has misused the data there. Now we are not being able to fix which one is the operator. So if I have to take 3 operators into cognizance, then why not the officer also who has given it? So that sort of sensitization is also required, where you shouldn't give it to them. And also we are having people at the lowest level, even the PPL, even in the sector 5, the software companies, the banks, etc. We are getting people who are entering data who can be, from where data can be taken easily. Sucharita, you must be knowing that data is probably the most lucrative thing now.
Yes,
for business.
Definitely.
And it is so very easy to get data that even officers like us, they are getting at least on an average 3 calls from different people that somebody wants to sell insurance, somebody wants to sell credit card, somebody wants to sell. And I asked them, why did you get my name? Why did you get the data? So it is very annoying that data are being leaked out, data are being sold out, data are being purchased almost at will, and we are not being able to take cognizance of this thing for the stringest of the laws. The laws are not, I don't think the laws are so very strict that we can stop this. So we have to think take into consideration that we must have very strict laws about this. Where the data are kept, they must be kept. I think Mr. Chatterjee has mentioned it, that where the data are kept, they must be kept very securely and safely. Otherwise, the whole concept of keeping data will backfire on us. And that is, in fact, already started happening.
That's right. So that actually brings me to Ritika. Ritika, what do you think of this? How do you address data protection and cybersecurity in an organization such as yours?
Cyber security is a bigger spectrum.
That's right.
And it cuts across various security principles and practices, and of course the related tools and processes. Data security being one of the newest one. And within data security, we also are now more interested in data privacy, because privacy and security are two different aspects. Depending on what kind of data we are addressing or protecting, we have to follow that particular principle, whether it talks about privacy of a person or the data owner, or it is a sensitive data which is, say, for example, not private, but it is confidential. Loss of it can lead to a lot of security issues. So data security and privacy are two different ladders within data security. Now, going to each of them, I'll take up separately. Data privacy addresses typically the private data of a person, typically. So whatever will help someone, a third party, to identify a person will be clustered as a private data. In GDPR, like we have talked a lot about GDPR here, so GDPR typically talks about protecting PII, personally identifiable information. Vis-a-vis, if we look into the data security part of it, security of data also deals with the commercial aspects as well. For example, the PHI data and PCI data. PHI data and PCI data are typically processed by either the health sector or the payment sector. For example, PHI is personal or patient health information. There are multiple laws across the world, which unfortunately in India we are yet to have it, but health records are being considered as a sensitive information, and we need to protect or secure data. If we go for any medical reasons or any medical processes we undergo, lot of data gets collected by the hospitals or the nursing homes or the health sector. How do they process it after the hospital period is over? Are they keeping it in their records, off records, on records, protected? I mean, whatever be the format of the data, be it on a pen and paper or be it on the virtual platform. So a lot of things need to be taken care of in terms of the patient health data, the payment card industry data, or the cards, for example, the debit card data, credit card data, or any wallet now. Nowadays, like mobile wallets has become a down.
Your internet, your voice is getting a little carried away.
No, it's showing me full signal. Maybe I'll talk a little louder.
Yeah.
So that is another aspect. So there are 3 different buckets of data which we need to protect.
First, can keep ourselves mute. Otherwise, we are not being able to hear Ritika properly.
Just give me a second. I'll just come back. Just give me a second. I'll switch off the. I think this will be a little better.
Yeah.
Sorry. So that's what I was talking of. So there are 3 different buckets of data which we need to look upon whenever we think of protecting the privacy or the sensitivity of data. Now, coming to the implementation part of it, yes, rightly you said, cybersecurity talks a lot about the implementation of the technology which goes in protecting any information asset which we have. And especially if we are talking about the data security part of it, there can be different technologies, tools and processes which we are actually using it in the IT industry for protecting the employee data or the customer data. Typically, there are data loss prevention techniques which we at present are using, which also includes data encryption, data masking. And I think we can touch upon these tools and techniques as we move ahead with the discussion.
Thank you, Very, very informative actually, and it also gives us relief that people are actually taking data security so seriously, because now that we have learned a lot about the law and the importance of securing the data that is collected. We know that the law is very important. We do need a law considering the kind of data that India is churning every day. So now the question is, of course, on the benefits of having so much data for the business. So I will take advantage of the fact that Professor Ravindran belongs to the education sector. And education, as we all know, is an immensely important sector. The personal data which is collected is not only huge, but it also includes data of children. So in the education sector, a lot of data which are collected from students, for instance, and for an institute such as yours, during the competitive exams like CAT, during the admissions, during the course, how do you envision utilization of this data on a macro level by the governments to benefit the education drives and the schemes, and also for an institute such as yours to create or customize and conceptualize new and variant courses, probably exchange programs, or even capturing employment trends of the students who graduate? How do you think the data that you collect, or an institute or an educational sector is collecting today, how will it benefit the institute and its stakeholders?
So again, one has to kind of divide education sector into the school and university.
Yes.
School minors comes into play. So obviously there is an additional protection which has to be provided by in terms of consent, in terms of parental consent, etc. Right. So if you look at again in that context itself, one could possibly say that one has to kind of differentiate between, say, private and public or government institutions. Possibly, I don't know. We still need to have clarity. Government schools, colleges may be governed separately, as they can be categorized as service provided by the government. We don't know, right? So education institutions are more likely to fall under the definition of data fiduciaries, yes, and the chapter 2 of the bill become applicable, right? So further, they will need to show compliance with transparency, accountability measures as per chapter 6. Given that the academic institution will also store and process a large amount of personal data of minors, they can be guardian data fiduciaries under chapter 4. So in some instances, institutes will be considered as significant data fiduciaries under section 26 also. But coming back to my institution, I mean, I am Calcutta, or as you said, the CAT, around 2 lakh applicants, and the process that we follow. Historically, and it's not about the current proposed bill or the IT law, but essentially we always keep this data confidential. So we don't share that data. Of course, after it has gone online, the CAT has gone online a few years back. TCS, for instance, is the company who kind of manages the test centers, the examination, online examination, etc. Right? But having said that, all the data of the candidates are confidential. We don't share. We don't even use it for academic or research purpose in that sense. So we don't use it for commercial purpose in that sense, right? So at best, what we would share is a list of the score to private institutions. That would give the name and the score only. Beyond that, nothing is kind of provided. So in that sense, and that is not just with the entrance exam, but also when they are registering, coming into the institution, registering all the personal data that they have, of course, are sensitive in nature. And historically, most institutions, including universities, etc., the student information are generally treated as very confidential without their permission or without their parents' permission. We don't use that. As I said, even for research purpose, forget about the commercial purpose as well.
Yeah, but if this bill becomes an act in its current form, is very valuable.
Yeah.
For the betterment also. So it's just not that the data is like we are constantly hearing is the new oil. So wouldn't you want to have a or whatever the different principles are there in this data protection law, to utilize it for the betterment of the students, and of course the country at some point of time, because these students are the future of the country.
Absolutely. These are rich data and unexploited data.
Correct.
But at the same time, since there is no legal framework as such, how a processing has to be done and how these data can be used, even for leveraging the information that is available or coming from the data, because there is no framework as such, we are even unable to kind of share it, even for the academic or research purpose, etc. Right?
So this law is very important, even from utilizing the data purposefully is concerned.
Absolutely. And for that matter, even our institution do have a course on big data. I mean, the analytics. We have a 2-year course specifically designed, of course, technical, mostly technical and managerial part of it. Legal part gets a side seat only, right? But that is the area where people want to go now. That is the area where jobs are. That is the future, right? And it will, in a way, kind of AI will replace many employment. Of course, will generate other employment, but yes. But yeah, I agree. I agree that this is one potential area where one has to focus on, and also to study, to understand and provide the needy students, especially the information and the needs, meeting the needs of the educational sector. Yeah.
So Joy is not being able to join, but I was really eager to ask him, about because
I have just been able to join back.
Oh, you have? Excellent, excellent. So you are now most sought after by me. So because now we are discussing, the business advantages of having a lot of data. And especially for a purely customer-based organization, having a shared economy model such as your organization. So do you think that data is the new oil, and why do you think so?
Sure. Firstly, good evening to everyone, and thank you for having me on this university panel. So first is Sucharita, I think I have a little bit of an issue in sort of categorizing data as the new oil. I think it's important, but to equate it with oil, I think is probably a little bit misplaced, because we don't really treat data in the same manner that we treat oil. I think the only similarity that I can find is that yes, oil is something that's there in the nature, and to get it out and process, you need certain proprietary, processes to be employed. And I think that's exactly where, in some ways that stops. But having said that, is data an important part of modern business organizations such as ours? Of course it is. The reason for that is, we can only provide a better service if we are able to process certain kinds of data. For example, it's only data which will sort of better a mapping solution for us, which is extremely critical for us. It's probably a data which is going to be able for us to be able to lead generate to independent drivers who sort of come onto the platform and tell them via a heat map that at X point of time you're more likely to get a passenger from Y area. So is Goriahat going to be more busy, or BBD Bagh at a particular given period of time is probably predictive upon the data analysis that happens. So yes, organizations such as ours would employ machine learning, AI, etc. to be able to do it, and to train all of these things you need big sets of data to be put into it. So yes, it's important, and from that perspective, I think we also have a responsibility, and in some ways as a corporate, and I think I think you were saying earlier, I think we welcome the fact that India is looking towards a proper data protection regime, which in some way would also help in clearing the air, laying down the standards. And we've, as a company, had very productive, discussions in front of the JPC, which was seized in looking into, the bill itself. I think we had fantastic meetings with them. I think everybody got, the understanding that we wanted to bring to the table, and we're really looking forward to the revamped, version of the bill, and see, how that's going to shape up.
So the data that an organization is building up, that can be used for making new products, that can be used for diversifying or expanding its product. So is that correct? Is that a correct take on this on this fact that data is very valuable? Like I now
It is
am
valuable.
the professor for the education sector. So my question to you is on a model that you belong to.
Right. I mean, it is important. There is no doubt. I mean, we would definitely want to get data and treat it in the manner that it deserves to be treated, in order to be able to bring our services, etc. to the people. No doubt, it's a valuable.
So before you logged out, Joy, UP had spoken on the privacy, key in the website or the privacy policy.
Yes.
So this privacy policy becomes a very important part of an organization, especially with the data thing being so important. And so what do you think that the privacy policy now, or an agreement now, like I was telling before, that when today I have to download an app, I just say I agree because I'm in so much hurry to get that app towards a 50,000 letter agreement, which I can't even read properly. And even the privacy policy of any organization can be very complex. It can have several clauses, sub-clauses, cross-references. How does it cater to an Indian population, where the demography is so diverse? So how do you think that once this law comes, will it not be improper to ask the privacy policy should also be in vernacular languages, or it should be read out for somebody to, give an audio consent? Do you think these customizations should be made?
I mean, I won't go to the extent of saying that a lot of customization should be made, because I think, here's the key thing, right? I think it's a question of striking a balance, right? It's a question of striking a balance between a legitimate interest that I have in protecting my privacy and my data and what is being done with it and understanding that, and also the legitimate interest of business of being able to bring that service in a seamless manner.
Joy, I've lost your voice.
On the service.
Yeah, now you're back. Okay.
I'm back. Okay. So the basic point I'm saying is it's all about a balance, effectively. So can we have vernacular languages? In many cases, like for example, in Uber, when we deal with our driver partners in several states, we do make available their contracts in the vernacular language. So that is possible. But is it possible, for example, for every business to customize it to very minute details? I would say probably not. And probably that's where we need to treat a little cautiously. Having said that, I think as a company, there are certain best practices which I'm sure a lot of companies follow. But as an international company, we do follow it. For example, principles of data minimization, that is collecting only what is needed. Don't, sort of collect everything and everything that you can. Be very clear about what you're going to process it for. So if you look at, for example, Uber's privacy notice, you'll be able to identify exactly for what we can process it for, to whom can we share it with, and under what circumstances can we share it with those people. For example, we categorically call out the fact that as Uber, we do not sell your data at all to anybody, right? And sharing is also in limited circumstances, for example, with law enforcement, right? If they send us a 93 CRPC, we will respond to it and give that particular data. But that's in accordance with law. But leaving that aside, those circumstances are very clearly sort of delineated. And I'm sure that's the best practice, which also the bill talks about, which is also there in GDPR, which is also there in the Australian Act, the Singapore Act, or in the US. So to that extent, I think corporates should be very okay, to sort of bring in the required transparency.
Right. Thank you so much, Joy. So we'll come back to Ritika because, of course, now we know that data is very valuable. It has to be collected, it has to be categorized, and also protected. So Ritika, we just left you on the ways of protecting data. So one of them is the question really is that what is the nature and the strategy of employee-oriented trainings and workshops in order to enable them to fully comprehend the privacy policy? And also, one important aspect is about the risk response mechanism, which is followed in the IT sector or the corporate houses.
See, whenever a new employee joins, be he or she in any level, there is always a mandatory training. We call it an iSecurity training, which covers the entire space of information security, including data security aspects. And it's a mandatory test the employee has to undergo a web course and therefore an exit test, and only after, in my organization, it is 100% scoring he makes, then only he'll be able to complete his joining induction program. So that in itself is like whenever somebody comes to my table, he or she is already ready with all the aspects of basic security trainings and the policies and practices that company follows. This is one part. And now if we go into a little deeper into it, like somebody, if into the consulting arena, if someone is being put up in a consulting role facing a geography, for example, EU or say US, then there are laws of land apart from what we follow here. So the security policies which we follow at organization level, we are also training our employees in terms of geography specific requirements in terms of cybersecurity and data security, which is a part of it. For example, there are multiple external security certifications as well in the market. Like I know Yukti also has done it. Data Security Council of India, they are doing a lot of very useful trainings in this front. And we are actually one of the lead assessors, certified lead assessors on data privacy from DSCI. And our team members are always encouraged to complete trainings like this so that we get the required knowledge from the ground, from the experts, and we bring it up to our clients, to our employees. And there are many other security forums as well, like ISACA being one of the leading world certification providing organization who are providing certified information security auditors, security managers, and a hell lot of trainings. So these are some of the very important security related certification programs which we always encourage our employees to take up and be up to date with the laws of the land, the laws of the country where we are serving the clients, and also the world as a whole.
So what happens, unfortunately, despite so many, checks and balances, still if there is a data breach or a corporate fraud, then what do you then immediately do? What step do you immediately take? Or
first thing,
your position
is intimate the data owner. The data owner must be informed. If we are serving in the EU, then anyways we are mandated by 3 days. Still, as a best practice from our organization or in the industry, we always intimate the data owner immediately about that, yes, there has been a breach or possibility of a breach investigation is going on. And we always have an emergency response team with respect to security incidents who immediately hop in and start with the investigation. So we typically call it ASOC. So ASOC is the team who take care of all these aspects immediately from an internal standpoint. And if it is required that it goes for some, say, bigger penalties in the corporate house and goes out, some external investigation has to, definitely we follow the law and order process of the place.
What about the criminal remedy aspects of it, Mr. Mukhopadhyay? How do you get and how do you sort of respond to it when you get a complaint like this of data breach? You're on mute.
Can you get me?
Yes.
Sujaita, actually in West Bengal we are having cyber police stations in each district. In the district headquarters there is a cyber police station. We are having a strong cyber crime unit in CID and also another unit in Lal Bazar for the people who are living in the jurisdiction of Kolkata. People can inform anonymously or by name to any of the cyber police stations, or they can straightaway go to www.cybercrime.gov.in. From there, the complaint goes to the corresponding unit immediately. So we call the complainant, even in CID, this is the practice, we immediately contact the complainant, get the gist of it and call him or her to find out what's happening. After that, we have very rigorous processes. We contact with if there are any companies involved in the social media sector, with them, or if there are individuals, then we go for them for the sake of privacy and secrecy. Also, we are not divulging the exact methods what we do there, but definitely in most cases we can do it, but in some cases we are having difficulties, which I mentioned earlier also. Say for an example, in a very recent case, money has been transferred to Bitcoin. Now that becomes a problem. The problem is the Nigerian problem. So then also the investigation agencies face some sorts of problem. You know, in the cybercrime sector, the anonymity is the biggest problem for the investigating agency. But over the years, we are also quite equipped with stringent and more stronger laws with us. We are definitely improving and having some effective investigations and also some good results in these crimes nowadays at present. Hello?
Yeah, now you can hear me?
Yes, you are.
Yes. Thank you. So we'll go back to Mr. Chatterjee once, and Mr. Chatterjee, in this law, there is this concept of right to be forgotten, which seems to be like the fundamental cornerstone of the right to privacy. So, do you think this right, in the manner in which it is conferred now, it is really a right, or is it too onerous upon the data principle? Because so many conditions have to be fulfilled by the data principle, which seems to have to satisfy the adjudicating officer. Only then he will have the right to be forgotten, he or she will have the right to be forgotten. So, and what is your take on the government intervention or interception so much? Because I was hearing and I'd rather reading an article where it was being said that excessive leeway and autonomy has been given to the government in this bill. What is your take on this? You're on mute now this time. So I was reading somewhere that this last year, the most spoken words are "you're on mute." So it's
actually,
like
the second question I will answer first.
Yes.
In terms of interception and law, yesterday we have seen consecutive 11th conviction in West Bengal. I think we should be. I am privileged to be special public prosecutor for all the 11 cases. And yesterday we got the second consecutive conviction for CID West Bengal, and I happen to be the special public prosecutor to that case. Intercepted evidences like the yesterday what happens in the name of lady, a fake Facebook account was created and some revenge was taken, and because this accused person was actually thinking of the bad behavior meted out to his girlfriend, and his girlfriend was a friend of the victim girl. So intercepted evidence is very important, but interception unlawfully, there are I think I'm audible. Yeah, so interception can be either lawful or it can be unlawful. Now, from the days of PUCL judgment in the year 1999, we see the Supreme Court has given a 9-point guideline, and on the basis of the same, we have an amendment in Indian Telegraph Act 419A. Later on in Information Technology Act, we have section 69, 69A and 69B, which is actually speaking of either blocking or taking the intercepted evidence. It is a accepted fact now, no investigation, no law enforcement agency can work without the law intermediaries or service provider providing the data, say for example IP address and other. Otherwise the investigating agency can't reach to the actual offender. So intercepted evidence is a very much required, because every time we are posting something to any website or anything on the virtual world, the log of that particular website is capturing the data in consonance with the same locate exchange principle, that somebody will leave some trace into the media here in the virtual media. So the point here, interception is good for a rightful investigation. It is required. And I was hearing some of the speaker was telling about, I think Mr. Kollan Babu was talking about these service provider not providing the data at the time. And this is a dichotomy that when there is a law in USA either under the USC 2701 or 2702, they are bound to provide the data to law enforcement agencies. Immediate things happens, an emergent situation arises, and that's sometimes happen the reverse in case of Indian agencies asking data from the foreign agencies. And it's a hard truth that in every type of investigation of this type, our investigating agency will have to depend on these platforms for the IP address and other things. So this is a big problem. But too much of interception, and that is why recently, in the year 2000, just few weeks ago, there was a rule came into effect, that is a media ethics rule, 2011, and that rule is very crucial, I think, in the days to come, because for long I was having some public interest litigations in one of the criminal divisions, in one of the REIT application before the Honorable High Court at Calcutta. I have raised these points. That is why these service providing company will earn or do their business in a million, and they will not share at the time of the investigating agency asking for crucial information. They will show us their policy that, okay, for these type of cases, we are not bound to provide the data, and only we are going to provide this data for this type. They cannot make pick and choose, because every crime is a crime, maybe on fake news, maybe of religious, sentimental, bigotry issues are there under Section 295A and 153. All issues are there. They are picking and choosing, making their policies, showing us that, okay, for this we're going to provide you the IP address. You can remember that case that is in Basirat. There was a riot. 2 months or more, the entire 24 Pargana North district was out of the civilization. There was everything coming out of that, and there was a riot and huge public vehicles and others have all been damaged and all. And I happened to be the ill-fitted and public prosecutor to that case, because their case was started because of a simple Facebook post. And in time of investigation, when the investigating agency was approached these service provider, I don't want to mention the name, they just, after waiting for 30-35 days, they answered that they are not going to provide you the IP address, because they will not going to provide the IP address in cases of any cases against religion or relating to religion or political. They are picking and they're choosing and they're providing. So interception is not always wrong, but too much of interception, say for example, after the PUCL judgment and other thing, I think when the Puttaswamy judgment came into being, we are on the threshold of getting a new law. We already have law from 2008 till date where the intermediary has to preserve our data. In the background of that, definitely interception, unlawful interception, indiscriminate interception is going to play a havoc for the people's privacy policy. And coming to your first question, that is, I think...
in fact, that is also a question which has been asked by somebody in the chat box.
Now, what is your first question?
On the right to forgotten, as to whether it is right.
Yes, madam. Yes, madam. The important point is right to be forgotten. It originates from USA. I think, if I'm not been wrong, 1993. Then later on, we heard about in the mid 20s, or I think 2014-15, there was a public interest litigation or a REIT application filed in I think Kerala High Court. Karnataka High Court as regards to the right to be forgotten. So right to be erased or right to be forgotten, I think is an valuable rights in terms of assuring the privacy right of a particular person. But the dichotomy, the problem with that, see for example, this new media which is coming up, because nowadays the paper media is vanishing almost. So we have new media, online media and other. So there are posts of, say for example, a person is arrested today. And one portal, news portal or every news agency has now an online editions and other. They make a publication with respect to that person who is involved into the crime. Later on, that person become acquitted from that criminal case and other thing. Then he can demand for right to be erased or right to be forgotten, so that he or she cannot be disturbed in their lives. So in perspective of that, I think there is the technological problem. One was speaking about the AI and all. So if you make a contrast between the GDPR and with that of big data analytics or AI or blockchain or cloud and all, they are at the dagger's dawn situation. What I am telling is, say for example, today we are having a thriving Internet of Things. And these IoT, the way they have the policy, the privacy policy they maintain for a teeny bit of device, it is exactly on the contrary or the reverse of the policy envisaged in the, say for example, in GDPR or in our bill. So next, definitely in case of blockchain and others. So that is where the point. if right to be eraser or any kind of data is already there and there are considerable analytics been applied into it, and a profile has been made against a person, and somebody downloaded the data, and maybe not in a particular website. What happened in my the first CID conviction case, a lady's video of her private part was shared to more than 35,000 online platforms. And some of the platforms was actually not from the one platform where it was first uploaded. It was downloaded and then again uploaded. So how can all these cases, in all these situations, this right to be forgotten or right to be eraser will be technically viable or feasible? It's a big question to me, when I already see that the very concept of the blockchain is not actually supporting or encouraging the basic concept of GDPR or the data privacy bill. Because there is absolutely immutable technology of blockchain will not going to support the concept of right to be eraser. If a data is there doubly encrypted in a block, and there is hardly an opportunity to get that data back and or change of data, then the question again comes, there is a data and some individual or company or they are working on that data, and there are later issues. Then when the question coming up for right to be eraser or right to be forgotten or right to be deletion, in that case the company who is working on the data can raise this point that we have considerably worked on this data and we have our IP or intellectual property right which is inherent to that data, and if it is everything deleted, what will be their data? So there are a lot of complex situations coming up. So in a single word, it cannot be answered. I think it's all we're waiting. We have to wait for the future to give all these issues, starting from blockchain and big data analytics, clouds, and this IoT. I think all have to be analyzed.
So we are actually looking at a huge expanse of legal development in this area, and how it can be aligned with the businesses, how it can be aligned with the entire ecosystem, and especially in a country like India. So we have
two concepts I must say is very important. One, I love to be with the GDPR and our privacy bill. I must say on a very optimistic note. One is the privacy by design. This privacy by design is a fantastic concept, because after commission of the crime, there will only be penalty or imprisonment. That is hardly acceptable in such a huge industry. So better we have a policy which will prohibit or protect or have a prohibitory policy against a crime to be, prior the crime to be executed or happen. That is one of the things I think, and the sandboxing for these people, the sandboxing concept of with the people who are working on these startup companies who are working on the AI and all. These are two fantastic concepts which is going to promote the industry, and on the other hand, we are going to honor the privacy of an individual person. I think we have to match both of them.
Very well, very well. So I have one question. We have a couple of questions because this is being, played in different medias. One is YouTube, one is Facebook Live, another is over here. So we have questions from all over, but I have been able to pick and choose few of them because time is also now almost over. So one is, if Yukti, if you could answer this, is it prudent for mid-level organizations to start having systems and teams in place for complying with the law, which will definitely come very soon, or should they wait for it to be enunciated? Now that the bill is in the Joint Parliamentary Committee, it is still being discussed, like we now also heard. What is your take on this, Yukti? You're on mute, Yukti. Yeah.
My response to that would be that yes, it's a good step to start preparing, because like we know in GDPR, a period of 2 years was given to organizations to be able to get their systems in place. And we have had our bill, the first draft, which was shared by the committee, for about more than 2 years now. So we do have an idea of the kind of drastic changes which are going to come. And this is also in line with what's happening internationally, whether in Southeast Asia or you look at Middle East. Most of the countries are following the GDPR right-based approach and coming up with their comprehensive laws. So India being a economy being run on data, we are going to be in line with GDPR. So it is inevitable that this law is going to come, and we do have a basic idea of the principles and the kind of obligations which will be there. So for an organization, it makes sense to start, prepping, start knowing, okay, when you're taking consents right now, like which is something I always advise, that keep your consent in such a way that it meets the threshold of the law which is coming in the future. Because if you talk about volumes, and in case, to be able to go back and do the same thing again, it is going to be a cost. So things which you can see foreseeably in the going future that this is going to happen. So it is better to have a system in place. You will need an information security scheme. It is also suggested that, a part of your legal or compliance, there is a team, there is at least somebody designated in the organization who knows that they're supposed to look at this.
Right.
So you don't need to call somebody and a data protection officer, but you need to have somebody who's responsible for this. And there needs to be a conversation about information security and data protection at the board level. So unless it doesn't come from the top, unless more and more boards are realizing how important and the risk associated with privacy breach, apart from the penalties and fines, which are obviously massive, it's also you lose your data, which is precious, right? So to have, if you were to take my view, it's always better to at least have an organization structure and start work on the basic tenets, and of course later on when we have a final draft, we can work towards it.
Correct. We have one question on the aspects of data localization and the challenges of applying it in the Indian framework. I would, if Yukti, you can take it, then great.
So data localization was one of the heavily debated topics when the first report had come out, committee report. And the view was that the sensitive data or the data should be kept in India and should not be freely transferable. However, if you look at the revised draft, this has been curtailed and it has been changed significantly, where this requirement is now for the critical data, which is a separate category which has been envisaged in the bill, which will be required to be stored in India. And for sensitive data, there is a requirement to keep a copy in India. Now, could you repeat the question or the exact concern?
Yeah. So the question here is, considering can the aspects of data localization and the challenges of applying it in Indian framework be covered? That's the question.
So if I were to look at the implementation of this, they've drawn a distinction between sensitive personal data and personal data. And you can transfer personal data, obviously, based on certain grounds of transfer, and those are laid down in the bill. And for sensitive personal data, you need to keep a copy in India. And for critical data, there is a separate requirement. The problem is that data segregation sometimes becomes a problem for organizations, because you might have a form where there is also normal personal data and there's sensitive personal data. To be able to segregate it and actually comply with the requirements for organization, it potentially looks like a difficult task. And with respect to critical data, we don't have clarity on what types of data will be classified as critical. And to be able to know today, how do I prepare for it? Because there are going to be requirements of keeping it within the country, and then your operations, if you're a multinational, could be affected. So, we don't have clarity on what will qualify, what will be that critical data. So in terms of, so these are the 3-4 problems which organizations could face.
Correct. So it is actually absolutely imperative that this law will come at some point of time. What appeared from today's discussion is that this law is very much required from the data security angle, as well as from leveraging the data for better business angle. And we have one last question, wherein I think it is for Mr. Chatterjee, where it has been asked that, sir, can you please refer any landmark case in regard to government interception?
Hello?
Or intervention?
I cannot hear landmark case on regard to?
With respect to government intervention.
In respect of government interventions of what?
For maybe summoning data or intervening into privacy of the population.
No, till date, actually, we don't have law. We have section 43, 43A. When every cases where there is a prosecution or investigation, when the alleged complaint is with regard to the hacking or unauthorized access, there is always a point coming into that. And for that purpose, the person, if ultimately his or her IP address or her details been captured, he can be called for under section 41A or other part for questioning and other. And from that perspective, it is okay. But that is why we need a wholesome law. I think section 43A is more of civil nature. And the prior coming of this, one point is very important. I forget to mention that. Prior coming to this law, that is this bill coming to effect, we already have a quasi-judicial forum in addition to the court and judiciary, that is cyber adjudication. And the cyber adjudicator formed under section 46 of Information and Technology Act, if anybody's breach, anybody access somebody's account, device and anything without his or her permissions, and in that case, or any kind of crime relating to the section 40, 43A, 72, 72A, which I've already mentioned, he can file a complaint with a compensation up to 5 crore rupees, and he can get compensation to relief to that effect. So anybody is not happy with the order of the cyber adjudicator, who is actually basically the secretary to the Information Technology Department of a concerned state, can go to the previously to the cyber appellate tribunal. Now it is only appellate tribunal in Delhi. And if he's not satisfied in appellate tribunal, he can come to the concerned high courts of the state. And you know that if he's not satisfied with the order, that can go to the apex court. So this is the one field where, except the law enforcement agency summoning a persons on this type of breaches and other, there are cases related to Information Technology Act, Penal Act, there are provisions which is actually covered by Indian Penal Code as well and other act as well. In that case, there are specific cases where the person is summoned and asked, even put to behind the bar, and investigation was made under custody and all this in case of non-bailable offences. But in case of other relief, we can have a cyber adjudication, quasi-judicial, quasi-criminal forum, and that is a cyber adjudicator. So both we have that already, but we are thinking more precise when the bill will come into play, that data fiduciary and this data owner, there will be always a conflict and how their data is used without their permissions. So that point will be covered.
Yeah, thank you so much. So sort of we can come to the conclusion that it is definitely a boom for the business, this particular law, but obviously it has to evolve much more for it to be adopted and properly applied in the Indian context. And I think that brings us to the end of the discussion as well as the questions. Certain questions have been asked, which I'm sure have been answered in some format or the other during this discussion. So I'm not prolonging this any further. And I would like Mr. D.N. Mitra to take over for the vote of thanks and for the concluding remarks. Thank you.
We were really engrossed more than 1.5 hours. It was really a very entertaining as also very educative and informative session. I hope that all the viewers, whoever has participated, they have gone back with something in their mind. I am very much thankful to all the speakers, who spoke very well. They performed very well. I particularly mention all the speakers, Mr. Vivas Chatterjee, Mr. Kullan Mukhopadhyay, Professor Rajesh Babu Ravindran, Ms. Jukti Sharma, Jayajyoti Mishra, and Ms. Kritika Banerjee. And last but not the least, our moderator Sucharita Basu, You have done exceedingly well. Now, with this, we come to an end. And before I end, I must thank the sponsors of this program. That is Acqui Law, Victor Moses and Company, Sandersons and Morgans, Quest Properties, and Hello Heritage. Thank you very much, these sponsors, for making it a good grand success. Thank you all. Good night.
Thank you so much. Thank you.